The judicial branch. So the judicial branch interprets the law. That means the judicial branch tells you what the words of the Constitution mean through the use of court cases. So the judicial branch does not just simply go through the Constitution and then look at the words and define them like a dictionary does. Instead, the court must wait for cases to come to it. And then, using the Constitution, it interprets the words of the Constitution and tells you what the words mean in that specific instance, in that specific case. And so the words of the Constitution have become more defined. That means we know more about what the words mean over time through the use of these court cases. The federal court, also makes sure the Constitution is obeyed through the use of judicial review. A big fancy term, which basically means the court can review, look over acts from Congress, from the legislative branch, and from the president, the executive branch, and see if those actions by Congress or by the president are actually legal or actually in accordance with the Constitution. As we'll see later under Washington's first term, and when we get back in January, it's going to be the case of Marbury v. Madison, where the court basically rules on judicial review and basically uses judicial review to declare laws unconstitutional or to declare acts by the president unconstitutional, which of course means if Congress has passed a law and the Supreme Court says, well, no, that violates the Constitution, that means the law Congress passes is really not a law because it never had that power to make that piece of legislation in the first place. Same way with the president's actions or the executive branch's actions. If the president or executive branch act in such a way that violates the Constitution, their actions are illegal. They are not legal, and that's what the Supreme Court does. It not only determines the words of the Constitution, what they mean through the use of court cases, it also enforces the Constitution. So if you want to be a federal judge, now you may remember some of the other branches, some of their qualifications. For example, if you want to be president, you have those three major qualifications. You have a specific age, and you have to have lived in the United States. You have to be a resident of the United States for a certain length of time, and you have to be a natural-born citizen. If you want to be a House member or senator, you have an age qualification, and you have a residence qualification. But under the Constitution, there are no qualifications. Basically, to be a federal judge, you have to be appointed by the president and confirmed by the Senate. So there are no age qualifications, there are no residency qualifications, there are no natural-born citizen qualifications. You simply have to be appointed by the president and confirmed by the Senate. Of course, your term of office, the president's term of office is 4 years, House members' term of office is 2 years, senators' term of office is 6 years. But nothing beats the courts, the federal courts, because their term of office is for life, in what's called good behavior is what the Constitution called it, but it's basically for life. However, you can be, like the other positions in government, you can be impeached, and if found guilty by 2/3 of the senators, you can be thrown out of office and lose that position as a judge. So the judicial branch is organized into 3 major courts. And this is the way we're going to be considering it. We're going to be considering the lowest level courts, the U.S. District Courts, the U.S. Courts of Appeals, and the U.S. Supreme Court. So if you want to remember it, just remember the word SAD, because starting from the top, that would be SAD, S for Supreme Court, A for appeals court, and D for district court. Technically, the court system is a little bit more complicated than that, as we see by this. It's a little bit more than just 3 boxes. However, having said that, basically, some of these other courts act like district level courts. So, for example, the Court of International Trade and the Court of Federal Claims. These courts are basically just district courts that are named something else. And then, of course, you also have some courts that are basically like the appeals court, except they're, again, named something else. So this is a little bit more complicated, but as far as 8th grade, we're just going to use the SAD system, Supreme Appeals and District. So the district court. The district court is the lowest level court and serves as a trial case where civil and criminal cases start. Of course, in a civil case is different than a criminal case. In a criminal case, you are accused of committing a crime, and if found guilty, you could lose your life, liberty, or property. That is, they could execute you, put you in jail, or fine you. In a civil case, the most you can hope to lose is some property. That is, they could fine you. So there's really 2 different types of these cases. So the district court is there are 94 district courts, by the way, with at least 1 in each state, and Texas has 4 of them. If you're in Pearland, you're in the Southern District Court. But the district courts, the district courts are like the courts you see on television. The courts there, they have a judge, they have a prosecutor, they have a defendant, and they have a jury. And just like on television, the prosecutors has a witness in the stand and is asking them question, and oftentimes the defense lawyer saying, "Excuse me, Your Honor, objection, Your Honor, objection, I object," and the jury decides the case. Well, that's sort of the district court, except actually, you don't have to have a jury. If both sides agree, the district court can simply have a judge. The judge can decide the case. But if one side wants a jury, you have to have a jury in the district court. And at the federal level, it has to be 12 people. And in order for you to have a verdict, you have to have all 12 people agreeing to the verdict. Now, that's a little bit different in state courts, as we see, but and as we'll see. But in federal district courts, if you have a jury, you have to have 12 people, and all 12 people have to decide. So, of course, we're used to criminal cases where you've committed a crime in the national courts and the federal courts. They consider crimes against the national government. So, if you committed a state crime in your state, that would be done at a state court level. But if you committed a crime against the federal government, or if you've committed a crime against a federal employee, or if you commit a crime on federal property, those are all crimes that can start at a federal district court level. And if found guilty, again, you could use your life, liberty, or even property. So the district court level, very important. That's where the criminal cases start. Now, you can also start civil cases. Basically, a civil case is where someone has been harmed, and the court seeks to make them whole, as it's called. So, for example, in a civil case, maybe you've bought a new car, and you've driven it home, and you park in your driveway, and you've forgotten your phone inside, so you want to go, of course, go inside and get your phone so you can take a picture of your car so you can send it to all your friends and make them jealous. But while you're inside getting your phone, you hear a big noise, you hear a big bang, you rush outside, and your neighbor's tree has fallen on your car and flattened it like a pancake. Naturally, you're a little bit upset because you spent all this money on a new car and you were just about to take a picture of it, and now it's all crushed. So what do? Well, you sue your neighbor. Because it's your neighbor's tree, and in your lawsuit you claim that your neighbor's tree was rotted, and your neighbor should have known the tree was rotted, and your neighbor should have taken actions to prevent that tree from falling on your car. And because your neighbor didn't prevent the tree on their property from falling on your car, therefore your neighbor is responsible. So in this type of case, a civil case, what the court does basically is to set things right, to sort of roll back history, so to speak, to where you had that new car before it was damaged. So to do that, obviously the court can't really roll back history, but what they can do is if your neighbor is found guilty, your neighbor could be forced to pay some damages. They could be forced to pay money. So you go out and buy the exact same model of car, exact same everything of car, and now you have that new car, and it's just like it never happened, more or less. And of course, you can never get over the trauma, I guess, but still, that's made whole. So those are civil cases, and again, in civil cases, the most that can happen is that you can be fined, so to speak. You can lose some money. So in the district court level, when the trial starts, there's some procedures you have to go through to make sure that the court case is valid. Of course, if it's a criminal case, the person's arrested has to be arrested there has to have been a crime committed, in other words, and there has to be reason to believe that person has committed the crime, and that person has to have been brought before a judge, or in other cases what they call a grand jury, and then the judge or the grand jury determines if there's probable cause, if there's like more than a 50% chance that person actually committed the crime, before that person can be brought before a district court, before that person's trial can start. So it's not just the police officer who arrests you that will get you to a court, that will get you to a trial. There has to be someone in between the police officer and the trial in order to determine if there's a probable cause as to whether you've committed the crime. So, and during this time period, when, for example, the police are questioning you, they can't force confessions out of you. And then, by the way, if they do force confessions, they can't actually use that in a court of law. They have to basically treat you humanely. So there are certain procedures the police have to follow in order to get you to a trial. And then once you're at the trial, there are certain procedures the court has to follow, again, in order to make sure it's a fair trial. And then the judge or jury decides if you're guilty, or of course, if it's a civil case, if you're responsible. So if you're found guilty in a district court, that's not the end, because you may appeal to the U.S. Appeals Court. The U.S. Appeals Court is in the middle between the Supreme Court and the district court. So basically almost all cases, 99.9% of all cases start at the district court level. Then if you lose there, you can appeal. Let's say that you're guilty and you've been convicted of a crime. You say, this is not fair. Or in a civil case, maybe you've been found responsible, but you still don't think you're responsible for the crime. Or not the crime, but the incident. In that case, you can appeal at your own expense to the appeals court. And the appeals court is, there are 13 appeals court that sit below the Supreme Court. and again, they're called Court of Appeals, and basically, there's also sort of an overarching appeals court called the Federal Circuit Court of Appeals, but it has a very specific purpose. It really doesn't hear appeals from district courts. It has a very small list of things that it can consider on appeals. But nevertheless, they're basically every state has a district court. But then the United States is divided in these 13, or basically it's divided into 12 appeals court, plus the one special sort of extra appeals court. So if you're in Texas, there's 4 appeals courts, and if you're in, I'm sorry, you're 4 district courts. And if you're in Pearland, you're in the Southern District Court. But if you appeal from the Southern District Court to an appeals court, you're in the 5th Court of Appeals, which includes Louisiana and Mississippi. So the appeals court, not quite like the district court. The appeals court is really not concerned whether you're guilty or innocent. They're concerned whether you've had a fair trial. And how do they know whether you had a fair trial? Simple. They read about it. Because while you're at the district court level, and you've perhaps seen this on television, there's usually someone near the judge's podium that's busily, almost looks like they're typing. And basically they're taking a word-for-word transcript of what everyone is saying in the courtroom, just in case you want to appeal, so the appeals court can read that to see if you have a fair trial. So, and of course, today there's other sorts of ways of doing that. There's also videotaping the trial, etc. But usually there's still a stenographer, as they're called. There's still a typist. They're busily typing away. And sometimes in the district court level, especially on television, you might have some hotshot lawyer says, would the clerk please read back what the defendant said? And they pull out the little tape and they read back what the defendant said. But really, the stenographers there is their job is to take a word-for-word record in case you appeal. So what does the appeals court look for as far as a fair trial is concerned? First of all, they look at that tape, they look at the transcript from the first trial, and see if there's the word objection. And you've all seen it on television. Objection, Your Honor. I object, Your Honor. Because if you or your lawyer did not object, apparently you thought you got a fair trial because you never objected. Duh. So basically, if there's no objection, your appeals will be turned down. Now, maybe you objected, but then the judge said sustained. And basically, when the judge on television says sustained to an objection, that means the judge is agreeing with you and your lawyer that there was about to be a mistake made. Maybe a defendant was about to testify, and you and your lawyer don't want that defendant to testify because they might be prejudiced against you in some way. And so you say, excuse me, Your Honor, that person's going to be prejudiced. Please don't allow them to testify. And the judge says, sustained. We're not going to allow them to testify. Well, in that case, you still have no grounds for appeal because your objection was sustained. But if you objected, and if the court judge said overruled, then you might have grounds for appeal. So overrules means that you object to say, that defendant's going to be prejudiced against me, Your Honor. The judge says overruled, and they let the defendant testify. Maybe that cost you a fair trial. On the other hand, maybe the defendant really was not prejudiced against you. And of course, because your attorney can question the witness and bring out any prejudice, just because the judge says overruled does not mean the appeals court will grant you an appeal. But if you've made an objection, and if the judge said overruled, and if what the judge did might have cost you a fair trial, then you might be granted an appeal. The appeals court usually consists of 3 federal judges. And these federal judges are not sitting around together reading your transcripts when you appeal. Usually they're separate. Maybe one might be in their office reading your transcript, but another might be flying away on vacation on the plane. They might be reading it. Another one might be at home. and they might be watching a little TV, and then they take a break and read your transcript. But eventually the three judges will get back together in person, or maybe by telephone or Zoom or something. And if two of the three believed that you have not had a fair trial, they will grant your appeal. Now, the appeals court does not act like a regular courtroom. That is, they're not going to invite your lawyers back to argue the case. They're not going to have a jury. They're not going to admit evidence. No. What they're going to do almost always is give you another trial, basically, and probably before the same judge, in the same court, in the same district court that you came from. But what they will do is they will instruct the judge not to make the same mistake twice. So if you had objected to this potential person that was prejudiced against you, and if the appeals court feels this person was so prejudiced they perhaps lied and things like that, then the appeals court will give you a new trial, but order the judge not to admit that evidence, not to have that person testify against you again. Now, almost never will the appeals court set you free. I mean, if you're in prison after the first trial and you've been found guilty, you will probably still be in prison by the time the second court case comes around. So very rarely does the appeals court grant you your freedom if you've been found guilty, especially of a crime in the lower district court. But let's say you're not happy with the appeals court. Let's say, the appeals court did not grant your appeals. Well, in that case, you can appeal to the super appeals court, the U.S. Supreme Court. There is one step you can do before you actually get to the Supreme Court, and that is you can ask the appeals court to hear your case en bloc. En bloc basically means that instead of having 3 judges decide your case, you basically have all the judges from that district. The Fifth Circuit Court of Appeals. You have all the judges from that district, and there might be as many as almost 30 judges, and they'd all get together, and they'll all consider your evidence, whether to grant your appeal or not. But oftentimes, your request to have all the judges in the district hear the case is turned down. And in that case, or if the court got together en bloc and basically again turn your appeal down, you could still appeal to the super appeals court, which is the U.S. Supreme Court. So the Supreme Court is the highest level and has mainly appellate jurisdiction. That is, 99% of its cases come up from below, basically from the district court, then the appeals court to the U.S. Supreme Court. But the Supreme Court does have original jurisdiction in 2 types of cases. That is, the Supreme Court can hear a case for the first time in any court, and basically act like a trial court. They can actually sort of have a trial, just like a district court, in 2 types of cases. So the Supreme Court has original jurisdiction in cases involving ambassadors, that is, members of another country that came over to represent their country, the United States. And another type of original jurisdiction is cases involving disputes among 2 or more states. So obviously, if Texas and Oklahoma has a dispute with each other, if you're in Texas, you don't want that dispute to be heard in Oklahoma court because Oklahoma will probably win. But if you're in Oklahoma, you don't want that case to be heard in a district Texas court because probably Texas will win. So in that case, if there's a dispute between the courts, you can, a dispute between the states, you can take it directly to the U.S. Supreme Court. Now, there are very few of these cases that are heard. First of all, because the U.S. has determined that even though they have original jurisdiction, that means they can be the first, they don't have to be the first, especially in cases involving ambassadors. So in federal statute and federal law, thanks to Supreme Court decisions, if you're an ambassador and somehow you think you've been wronged in the United States and you want to sue, or maybe you've been charged with a federal crime in the United States and you're an ambassador from a foreign country, probably your case will still start in the district court level. Now, by the way, there are almost none of these cases with an ambassador because countries send their ambassador over to represent their country to the United States, and they want to make a good impression on the United States. Most countries don't war with the United States. Many countries want something from the United States, like money, foreign aid, things like that. And so countries generally do not send over their worst people to be ambassadors. They send over their very best people to be their ambassadors. So most ambassadors and foreign personnel from other countries, they're really top-notch people. They're not likely to commit a crime. And by the way, if they do commit a crime, there's several things the U.S. government can do. One is simply to send them home. And in some countries, if they've sent you over here to represent them and you have committed a crime and made the home country look bad, when you get back to your home country, things will not be looking very good for you. And in fact, in some of those countries, you might not want to go back to your home country because you might not survive the welcome they will give you. So nevertheless, most of the cases of original jurisdiction from the Supreme Court has been cases involving 2 or more states. And interesting enough, even though the Supreme Court can act like a district court, what generally happens when they have a case involving dispute among 2 or more states, they actually sort of appoint a judge to sort of hear it at the district court level, and then all the evidence and trial stuff is presented at this lower court, sort of special district court level, and then once that special judge has decided for one state or another, then the Supreme Court will basically read over what that judge has done and has either confirmed their decision or not confirmed their decision. So, but those cases are extremely rare. Usually the Supreme Court simply serves as a super appeals court. And there are thousands of cases appealed to the U.S. Supreme Court every year, and probably 50,000 cases. But of those, only about 100 cases does the U.S. Supreme Court actually take a case. There are 9 judges on the U.S. Supreme Court, and it takes 5 out of the 9 to grant your appeals. Because again, basically these are super appeals. Again, if you're the criminal case and you didn't want that witness to testify, and the appeals court ruled against you, and you get your case to the Supreme Court, 5 judges think you did not have a fair trial, then they'll probably still order a new trial for you. They will probably not release you, and then the super appeals court, the U.S. Supreme Court, will order the judge not to make the same mistake twice. So the Supreme Court has limited time, can't hear all these cases, even though there are 9 judges. The 9 judges hear the case together. Now, by the way, they don't actually have to hear the case. In most of the 100 cases, actually, they don't take oral arguments. In most of the cases, they simply have your attorney send a written statement, some arguments about why the Supreme Court should grant the appeal, and then they have whoever's representing the other side send arguments about why they shouldn't grant the appeals, and then again, sort of like the appeals court, the judges read it over at different times, and then the judges, usually about once a week, get together, and then they simply vote on it. And they say, okay, in case number 112345 from Alabama, how many affirm the case? How many don't? And they decide whether to grant the appeals or not. So the U.S. Supreme Court does not hear many appeals. In fact, it takes several judges even to hear the appeal. Your appeal is not automatic. Again, with 50,000 people appealing to the U.S. Supreme Court, the court only takes very few cases, and probably of those 100 cases, probably only about 30 or so do they actually hear the case, where there's 9 judges sitting on the bench, so to speak, sitting in seats, and where your attorney argues and another attorney argues. And by the way, in the Supreme Court, they don't bring up witnesses, they don't bring out evidence, there's no objection, Your Honor. They're simply one side presenting their case. They're usually reading off a sheet, usually for about 30 minutes, and then the other side reads off their sheet for about 30 minutes, and the court thanks them both for their time, and then the court goes away, and then about a week or two, or maybe several months later, the court votes on what to do. So it's not very dramatic. It's not like a court you see on television. Now, I should point out, so far we've been talking about the national courts. But I should point out, state courts are separate from the national courts because of federalism, where the national government has power and the state government has power. The national government has power to create criminal laws and civil laws, and the states have power to create criminal laws and civil laws. So those two groups of laws are different, and therefore you have two different courts to hear state cases and federal cases. But having said that, most state courts are very similar to the federal courts. That is, most state courts have a sort of a district court, just like the federal district court. Most states have an appeals court in between, just like the federal district court. And most states have a state Supreme Court, just like you have a U.S. Supreme Court. Most states. But of course, Texas is not like most states. So here's the federal courts, your three-box system. On the other side is the Texas court system. So basically, we do have a district court here in Texas, which hears criminal and civil cases, but we also have something called a county court, which basically also hears civil and criminal cases. And below a county court, you have justice of the peace courts and you have municipal courts. So basically in each county, you have cities, and in those cities, a municipality, you have municipal courts. And usually they decide cases that don't involve jail time or very little jail time. And if it's outside of a city, then you have something called a JP court, a justice of the peace court, which again, usually decides cases that do not involve jail time or very little jail time. So if you're unhappy with any of those, then you go to the county court. Or if it's a more serious case where you might get county jail time, you go to a county court. If you might get state jail time, you start at the district court level. Then both the county and district court can appeal to the the Texas Court of Appeals. But then, notice Texas has two Supreme Courts because we're Texas. Duh. Texas actually has a Supreme Court and a Court of Criminal Appeals. So the Texas Supreme Court really only decides civil cases, while criminal cases are decided by the Court of Criminal Appeals, which is like the Supreme Court for criminal cases. So again, Texas is a little bit different because, well, we're Texas and nobody else is. Of course, also something you need to remember about federalism is, and this could be somewhat embarrassing and somewhat dangerous if you're prone to criminal activity. So there's a clause in the U.S. Constitution which says, no person shall be subject for the same offense to be twice put in jeopardy or life or limb. That's called double jeopardy. So that means if you've committed a crime, like say you robbed somebody in the state of Texas, and the state of Texas brings a trial against you in a state district court, and you're found not guilty, the state of Texas can't come back in a year and says, oh, you know what? We didn't like that verdict. We're going to bring you to trial for the same crime again. Can't do it. That's called double jeopardy. Same thing in a federal court. If you start at a federal district court level for a federal crime, and the jury finds you there not guilty, or the judge there finds you not guilty, the federal government can't come back afterwards and say, oh, you know, we didn't like that verdict. We're going to try you again to see if we can get you guilty. Can't do it. However, what all you budding criminals should know, and hopefully none of you are, but again, because the state level and the district level are separate because of federalism, you can actually commit a crime that involves both the state governments and the federal government at the very same time. So if you go in and rob a post office, Stick them up. Give me all your stamps. You've committed a state crime because you have robbed someone in the state of Texas. And you've done it at gunpoint. It's aggravated assault. So if they bring you to the district court level in Texas and you're found guilty, you could be spending some time at the state jail. However, you robbed a post office. And a post office is federal property. And those were federal employees, which means you've committed a federal crime, which means the national government can bring you to the federal district court and try you. And if found guilty, you could spend time in a national government jail. And you go, but wait, there's double jeopardy. You can only try me once. Nope. Sorry, the U.S. Supreme Court says. Thanks to federalism, the state crime is different than the federal crime. Two separate groups. Unlucky you. Now, as a matter of practicality, generally what happens is, in a situation like that, the state and national government basically call each other up and says, do you want the case? Do you want the case? Okay, you can have it. So generally, it's just generally tried in one court, like probably the state court in this case. But if the state court finds you innocent, it's possible, probably not probable, but it's possible the national government will come and arrest you and try you in the national court. And you might be found guilty in the national court and spend time in the national jails. It's so hard to be a criminal. In fact, I remember one case where they kidnapped someone. They did not take them out of the state, which kidnapping is a federal offense if you move them across state lines. So they kidnapped the person in the state, and then they took them and buried them under some dirt or whatever with a little hole so they can breathe or whatever, and then they collected the ransom. And eventually, because they collected the ransom, the person was released, but eventually the police found out who it was and brought them before the state court, and there was some sort of the criminals involved apparently threatened the judge's child with some danger if these people were found guilty. Now, by the way, ordinarily that means that you get a mistrial. That means you have to start the trial over again. But in this case, the jury came back with a verdict of innocent. And so, of course, these criminals thought they were, home free. But as they got up to leave the state court, two gentlemen introduced themselves as FBI agents and placed them under arrest for kidnapping because the criminals had not taken the person across the state line, but what they had done is they had buried them a few feet into a national forest within that state, which means they committed a crime on national government land, which made it a federal crime. And those people were then tried and convicted in a federal court. And that is not double jeopardy. So it's tough to be a criminal these days. So my suggestion is don't be a criminal and you won't have to worry about any of this. Now, also, if you appeal your case from a state district court to the state appeals court to the state a state Supreme Court, if you don't like the verdict, you can appeal directly to the U.S. Supreme Court if it involves a constitutional issue. So if it's a parking ticket, and you get to the Texas Supreme Court and they strike you down and say, go home, this is stupid, pay your fine. You're not going to be appealing the parking ticket to the U.S. Supreme Court. But if it involves a federal issue, a constitutional issue, then once the state Supreme Court has ruled and you don't like their verdict, you can appeal directly to the U.S. Supreme Court. That is, if it involves a constitutional issue and you've been at the state Supreme Court level, you don't have to go back and start at the federal district court, federal appeals court, and then the Supreme Court. You can go directly from the state Supreme Court to the U.S. Supreme Court, but again, only if it involves a constitutional issue. And again, remember, just because you appeal does not mean the U.S. Supreme Court is going to hear your appeal. In fact, it probably will not. So there's no judicial appeal from the U.S. Supreme Court. That is, once the U.S. Supreme Court has made its decision, tough luck. There's nowhere else to appeal in the federal court system. But you have to remember, the federal courts, they're just one branch of our national government. They're just the judicial branch. So if the judicial branch can help you out, maybe the executive branch can help you out. For example, if you've been found guilty of a crime, a federal crime, and you've gone all the way to the Supreme Court and they've turned down your appeal and you're sitting in that federal jail, remember, the president has a power of pardon and can set you free and erase your criminal past from that crime. So you can use the executive branch perhaps to get the result that you want. And if that doesn't work, you can use the legislative branch to get you free. Now, by the way, the legislative branch just can't change the law that you're convicted of and you get out, because you're convicted under the laws of the time. And simply because they change the laws later on does not mean that you will be set free, because at the time you committed the crime, it was under a different set of laws. But what they can do, for example, they might change the Constitution. And remember, the U.S. Supreme Court is basically just interpreting the Constitution. They're basically the referees with the rule book. And if you're in a basketball game and you travel, if you're walking with the ball down the court, the referees are going to blow the whistle and say, sorry, you're traveling, you're turning over the ball to the other team. Unless you get the state athletic association to rewrite the rule book where you can carry the ball. And then the referees won't be blowing the whistle, because it's in the rule book that you can carry the ball, that you can walk with the ball down the court. Same way in our national government. If you don't like the rules you're convicted of, if you don't like the rules that got you convicted, you can change the rules by changing the Constitution. But to change the Constitution, that requires the amendment process. And the amendment process basically requires the legislative branch, the Congress of the United States, working together with the states. So to change the Constitution, generally what happens is that 2/3 of both the House and the Senate of the United States suggest to change the Constitution. And then 3/4 of the state legislatures have to okay the changes. So that's the way we change our Constitution. So you don't have to live under dead people's rules. Even though parts of the Constitution have been around ever since they were written in 1787, you don't have to live under those rules if you can convince enough people to change them. So again, you can get 2/3 of Congress, both houses, to basically suggest to change. Now, by the way, if Congress is not on your side, you can actually have the states call special elections and get 2/3 of the states to agree to your change. And then, again, the states have to approve those changes. And again, in the states, you can call special groups called conventions to approve those changes. That's actually been done once. But generally what happens is you get the state legislature to agree to a change. And if you get 3/4 of the state legislatures to agree to the change that Congress suggested, then you change the Constitution and change the rules. So again, the Constitution has worked pretty well over this length of time. There have been very few changes, formal changes to the Constitution over 230 years. But again, you don't have to live under the rules you don't want to. And the writers of the Constitution realized that one day people may want to change the rules. So they put in a system so you could change the rules legally and without violence. Because they remembered back when they were writing the Constitution in 1787, They remember just a few years earlier when they had to fight the British government, when they had to shoot at people, where they had to kill people, where some of their friends got killed in that American Revolutionary War in order to change the rules they lived under. So certainly that's the last thing they wanted here in America, that you would have to fight and maybe even die to try to change the rules that you live under. That's why they installed this process, this amendment process, to change the rules. And we'll look more closely at the amendment process at a later stage. So thank you. This was the Judicial Branch.